Hi, my name is Kirkpatrick. Insurance companies are becoming increasingly aggressive at trying to settle folks' cases well before they should. Recently I got a call from a friend of mine who was in an accident up north. His car was totaled. He was very badly injured, and the insurance carrier had already contacted him within a few days after the accident, acting like they were his best friend. The insurance company told him that they would take care of everything, that they wanted to get his case done as soon as possible. So they offered him some money. They offered him some money for the medical expenses he had incurred, which included an emergency room visit at that point. They were going to give him a certain amount of money to pay for what they anticipated would be medical bills that he might incur getting treatment for his injuries. And then they were giving him an amount too for the pain and suffering. Well, my friend was sort of excited about that and really thought that the insurance carrier was his friend going to take care of him and make everything right. As I talked to him a little bit more, though, I found out that he hadn't been able to go back to work. He was laying on the couch, couldn't get up. He hadn't been to his own family doctor yet to find out exactly what was wrong with him. He hadn't had any MRIs or any testing of that nature. Didn't know how long he was going to be looking at recuperating in terms of physical therapy and what other treatment he might need. And furthermore, he didn't know when he was going to be able to return to work. The point of all that is, as I explained to him, you can't settle that case without knowing where you're going to land in terms of all of your injuries, your lost wages, your pain and suffering, and your medical bills. It may seem great that an insurance company is coming to you and offering $25,000, but if in the long run that injury is going to cost you $30,000 in lost wages and $50,000 or more in medical expenses, that $25,000 right now on the spot doesn't mean anything. Now, I think what the insurance companies do, they look at the nature of the accident, because I've had them come in on small cases where it's a low impact and maybe they're not injured too badly. They've had a couple of visits and they offer a few $1,000s. And then on this gentleman's case where his car was totaled, clearly it was a very high impact collision. Well, they're offering a little more money, but that money doesn't amount to anything if the future damages are unknown and we don't know what is going to happen for the future. So I caution you against these aggressive insurance companies that come to you within 3 or 4 days after the accident while you're laid up in bed, and they offer you money. My suggestion is you wait. Always wait. There's no hurry. Wait until you know what your injuries are. You know that you've finished with treatment. You know what kind of work you're going to be missing. You can calculate your lost wages. If you don't, you're taking a big risk by settling your case before you know the full extent of your injuries. Even when people come to me, they may ask me what their case is worth right after the accident. The fact of the matter is, I don't know. And any lawyer that tells you they do know the value of your case within a few days after your accident probably isn't telling you the truth. Well, we don't know because we don't know what your treatment's going to be, what your lost wages are going to be, what your medical bills are going to be, and then the amount of pain and suffering that you're going to have. So the question might come up is, why can't you tell me that, Eric? You've been doing this stuff for 33 years. Well, the reason being is your elements of damages that you can recover from a jury include your pain and suffering, not just what you have right now, but what you're likely to incur into the future. Your medical bills, what you've incurred, and what you're likely and reasonably expected to have to pay into the future for your injuries. Your lost wages, what you have, not only what you have incurred, but also what you might incur later on down the road. Those elements I can't tell you what the damages would be, what damages would be recoverable unless and until we know the full extent of your treatment. Maybe you question, how long should I wait? Well, you don't want to settle a case or resolve a case until you know the full extent of your injuries. Your lawyer should know that, and your lawyer doesn't want to settle your case before he knows the full extent of your injuries. But we have to keep in mind one thing, and that's the statute of limitations. The statute of limitations is the period of time you have in which to file an actual lawsuit against the responsible party, or parties, depending how many people were involved. A lawsuit not filed within the appropriate period of time may be forever barred. So even if you're not finished treating with your injuries, a lawsuit still needs to be filed within that statute of limitations. The statute of limitations for most injury cases is 2 years from the date of the accident. It's different for workers' compensation injuries and for different types of claims. If you don't have a lawyer and you haven't filed a lawsuit, don't wait until that 2-year mark. And also, if you do have a lawyer, defer to your lawyer on the statute of limitations, because it might fit a specific fact pattern that might not fit within the typical period of time. With that said, if you have any questions, give me a call. My name's Eric Kirkpatrick at Kirkpatrick Law Offices, 618-239-6070. Thank you.